we learned already in the lecture about federalism how difficult, how complex it is to interpret this rather old document. What did the framers mean by interstate commerce? What did they mean when they talk about freedom of speech, freedom of religion? How do we adopt this document and make it meaningful today? I think the easiest way of answering the question is by saying the Constitution is what the judges say it is. There are multiple interpretations. Whatever the judges say at a given period, that is the current constitutional interpretation. Consider the tremendous power these 9 judges have. Not only do they have the power to interpret the Constitution, instill meaning into this old document, but they also have the power to determine their own agenda by picking and choosing the type of cases they think the Supreme Court should hear. It takes 4 out of 9 judges to vote in favor of accepting a case. Thus, the court has the unique ability to determine its own agenda. The Supreme Court does not have to render a ruling on gay marriage. Is this a constitutional right? The Supreme Court does not have to render a ruling on abortion. It is only if the court chooses to hear a case that came up through all the lower courts that then the case will move to the Supreme Court's docket. This link here is a listing of civil liberties-related court cases decided by the court in 2013. It gives you an idea of the really type of cases, the importance, relevance of cases heard by the court. How can a document older than 230 years be applied to contemporary issues? The Constitution is what the judges say it is. I want to explain this more by looking at how the Supreme Court has interpreted cases related to race and cases related to sex. The first comparison are 2 cases related to race: Plessy v. Ferguson, 1896, Brown v. Board of Ed, 1954. Plessy v. Ferguson, 1896. Is segregation a violation of the Constitution? This case, we will talk about it more in the civil rights section, involves Homer Plessy, a man who is 1/8 African American, and because of one-drop rule laws, defined as black. Can he sit in a white-only train car in Louisiana? The court argued no. The court argued that this law, segregating train cars, is merely a legal distinction between the white and colored races, a distinction which is founded in the color of the 2 races and which must always exist so long as white men are distinguished from the other race by color. So the court is saying, isn't it the most natural thing to distinguish races by color and segregate them? And such a law, the court continues, has no tendency to destroy the legal equality of the 2 races or reestablish a state of involuntary servitude. Segregation, the most normal thing in the world. In Plessy, the court also talks about separate but equal. Keep in mind that little emphasis was paid to the equality principle. 58 years later, Brown v. Board of Education, same Constitution, same application of the 14th Amendment. Can schools segregate? No. For the first time now in 54, the court is saying no. First, the court acknowledges that education is perhaps the most important function of state governments. And then the court asks the question, does segregation of children in public schools deprive the children of the minority group of equal educational opportunities? We believe it does. Segregation of white and colored children has a detrimental effect upon the colored children, even greater this detrimental effect when it has the sanction of the law. For the policy of separating the races usually is interpreted as denoting the inferiority of one race and the superiority of another race. Same constitution, different courts, different interpretations, because the judges on the court bring different values to the case. Let me make a similar distinction. The two cases you see here, Bradwell v. Illinois versus the Alabama case, deal with gender discrimination. In 1873, the court considered the question whether or not can women practice law. Myra Bradwell passed the Illinois bar exam, applied to the state for a license to practice law, and is denied such a license. Without license, she can't practice. Ultimately, the Supreme Court affirms the lower court's decisions. No, Illinois does not need to grant her a license to practice law because God designed the sexes to occupy different spheres of action, and it belonged to men to make, apply, and execute the laws. This is the truth, not women. Men make, apply, and execute the laws. Thus, women cannot practice law. What you see here is a direct quote from the 1873 decision. More than 100 years later, can an Alabama law make it more difficult for women to serve on juries? Typically what happened with these jury laws is that men were drafted into juries, yet women had to apply to serve on a jury. And you can imagine that not many people voluntarily apply to serve on a jury. Why? Based on the assumption that women's place is in the home, not in the public sphere. Thus, they should not be forced to serve in the public sphere. The Supreme Court rules that such discrimination on the basis of gender by the state violates the 14th Amendment, the Equal Protection Clause, especially in this case, because this discrimination serves to ratify and perpetuate old-fashioned, archaic, overbroad stereotypes about the abilities of men and women. So in 1873, these stereotypes informed the court's decision. In 1994, the court ruled the opposite. Stereotypes about the abilities of men and women cannot influence state laws. Same constitution, different interpretation. So the Constitution is what the judges say it is. What can we learn from these comparisons? There is not one ultimate wisdom to be derived from the Constitution. The meaning the judges arrive at depends on the nature of the times, cultural context, and their own personal values. Up to this point, we compared decisions across different time points. But let's now look at how judges making a ruling at the same time in the same court can also differ in their interpretation of the Constitution. Take, for instance, the landmark case Roe v. Wade, 1973. This is the case that established abortion rights for women. Prior to 73, abortion was illegal in all but 2 states. In 73, the court has to decide on the question whether or not there is a constitutional right to have an abortion. 7 of the 9 judges said yes, it is, within certain limits. Roe v. Wade established a trimester solution. As the pregnancy advances into the 2nd and 3rd trimester, the state's ability to regulate and restrict abortions increases. But how did they arrive at this reasoning? Note, not surprisingly, the Constitution does not say anything about abortions. Roe v. Wade was decided on the basis of privacy rights, but the Constitution does not mention the word privacy either. So how did the judges come up with privacy rights? Are there any elements in the Constitution that suggest that the framers valued privacy? Maybe, depending on how you look at it. The First Amendment, for instance, bans Congress from establishing a religion, from interfering with free speech, from interfering with the free press. One could get the idea, one could get the notion that the intent was to create some kind of bubble of privacy surrounding individual actions, protecting individuals from excessive governmental interference, if you buy this argument. The Fourth Amendment talks about the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Maybe we can find here the same bubble of privacy, individuals being protected from an excessive government interfering into their private lives. Other possible candidates would be the Fifth Amendment, the Ninth Amendment, for instance. In addition, constitutional interpretation is also heavily influenced by legal precedent, previous court decisions. Privacy came up for the first time in 1965, Griswold v. Connecticut. This case involved a Connecticut law that prohibited doctors from discussing information about contraception with their patients, even married couples. Information about contraception was labeled obscene, thus could not be discussed. The court invalidated the Connecticut law, arguing that it violated the right to marital privacy. So here we have privacy for the first time. Then in 1973, some of these privacy arguments are applied to the Roe decision. And here is an excerpt of the majority's opinion. And they're saying, no, Constitution doesn't explicitly mention privacy rights, but the court has recognized, the court sees certain areas or zones of privacy. They point toward the First Amendment, the Fourth, the Fifth Amendment, the Ninth Amendment, as well as legal precedent, the Griswold v. Connecticut decision we talked about earlier. Then the 7 judges in the majority go on saying, so yes, there are personal privacy rights, and they relate to contraception, family relationships, child rearing, education, and also family planning and choices over pregnancy. A minority of the judges strongly disagreed. Judge Rehnquist, who wrote the decision for the minority, 2 judges voted against legalizing abortion, says, No, there's no right of privacy in this case. Texas prohibits women from having an abortion. Has nothing to do with privacy, especially not with the type of privacy from searches and seizures protected by the Fourth Amendment. Now listen to this strong language. I find nothing in the language or history of the Constitution to support the court's judgment. Rehnquist argues that the court simply came up with a new constitutional right for pregnant women and with scarcely any authority create such a right against all existing state laws that banned abortion. Rehnquist calls this an exercise of raw judicial power. Maybe the court had the authority to do this, but according to him, this is an improvident and extravagant exercise in the power of judicial review. So how should we interpret this document? Should we aim at a more literal interpretation of the Constitution? A position often referred to this notion of judicial restraint. Interpret the Constitution literally. If the framers didn't mention abortion, the court cannot simply create abortion rights. Or, alternatively, judicial activism, a position often being associated with a more liberal court, the attempt of finding maybe new meaning in the Constitution and adopting the 230-plus-year-old document to changing times.